Now, the United States Supreme Court has also said that the press and general public do have a constitutional right of access to criminal trials under the First Amendment. You're damn right about that. Nobody wants Tyler Robinson to be unfairly convicted. Like, if the guy didn't do it, we're not like, well, we have to convict him. I think he did. All the evidence says he did, but we want to have transparency in the process. Now, the parties filed a joint motion to order a transcript of the hearing and classify both the transcript and the audio as private. Charlie Kirk trial. We are now moving forward towards a closure hearing. Remember, we've been battling about public access to this case and to this trial. This is a filing here in an order coming from the judge, Judge Tony F. Graff, specifically about public access and what's going to be happening next in this trial. The judge, you recall, is this guy right here, Judge Graff. The case is against Tyler Robinson, the alleged Charlie Kirk assassin, who is now being prosecuted. And we had the media last week submit a filing into the court saying, hello, we need access to the secretive hearings and proceedings and transcripts that you're having because we have a public right to know. They submitted that. The defense has now responded. And here is what Tyler Robinson's people are saying in response to the media saying we want more access. They write, all right, Judge, the defendant is now here. We're responding to the request from the media. The defense saying this: Mr. Robinson does not object to providing the notice that's required by the law. Okay, if we're going to lock the hearings down and kick the press out, the defense is saying we know there is a law, we comply with that. However, the requests made by the media are overly broad. They're way too burdensome, and you should strictly interpret these notice requirements because they can get access to the files online. Now, the media said when they came in, we want notice of and to be served with any petitions, motions, or request to seal. We want anything that the court is doing. The news media should be afforded an opportunity to be heard and to make argument to the court prior to any such closure. And they said we can't do that. The rules don't want us to give expansive notice requirements to alert the media when we're doing stuff in secret. First, the intent of the rule is about access. Okay, we don't have to notify them because they can go get access after it's happened. In this context, court record is defined as a record prepared, owned, or received by the courts. And when a motion comes in, we'll follow the rules. But you should strictly interpret the rules, meaning we do not have to give notice of motions about limitations on electronic media coverage. Okay. Media says, please notify us if you're going to limit electronic media coverage. They say, we don't want to, we shouldn't have to. This court may terminate or suspend electronic media coverage at any time without prior notice to the media. They're setting the rules. If the judge finds that electronic media coverage is no longer appropriate. So we want to kick the cameras out. Therefore, don't require us to give notice to the media. We don't want the media to have a say in locking down these proceedings. Second, Mr. Robinson acknowledges, the shooter, allegedly, that the Utah Supreme Court precedent advises that notices and requests to close court proceedings be given to members of the media who've made written requests for this. And so to protect against any potential claims that notice was not given, the court encourages the party seeking disclosure to serve advance notice, and all we can do is just file. Okay, as soon as we file any motions, they'll have notice. So don't make us give the media notice, make the media monitor the docket, and as soon as documents are filed, they'll get the notice. We don't have to give them more information. Now, the United States Supreme Court has also said that the press and general public do have a constitutional right of access to criminal trials under the First Amendment. You're damn right about that. The Utah Supreme Court has also said there is a presumptive right under Article 1 for significant access, but this right is not absolute. And while criminal proceedings and open proceedings give assurances of fairness to both the public and the accused, there are some limited circumstances in which the right of the accused to a fair trial might be undermined by publicity. For example, Utah Supreme Court has said that allowing blanket inspection of exhibits might hinder the process. And so as the court considers any request by the media about the court classification or closure motions, okay, both sides are trying to close this up. Prosecutors are, the defense are. Media is trying to wedge themselves in and say, please don't allow this to happen. It is critical that this court consider the realistic likelihood of prejudice to Mr. Robinson's right to a fair trial. This is such a scam. To preserve a defendant's right to a fair trial courts have affirmative constitutional duties to minimize the effects of pretrial publicity that is prejudicial. Okay, tell that to Derek Chauvin, all right? Tell that to Kyle Rittenhouse. Tell that to Donald Trump. Tell that to the J6 defendants. Trial courts must be especially vigilant to guard against any impairment of the defendant's right to a verdict. In doing so, the Supreme Court has encouraged trial courts to take steps to protect the process from outside interferences. Okay, and just to be clear, this will be a jury trial, and at the jury selection called voir dire, they can ask questions to disqualify the bad jurors, just like happens at every trial. Did you see any of this in the news? Did you read any articles about this? Where do you get your news from? What do you read online? What communities are a part of? Who has texted you about this case? Oh, nobody has? Great. You have no pre-trial prejudice because you know nothing about it. Come on into the jury. Happens every trial. Happened in Derek Chauvin. Lots of pre-trial publicity for him. They still selected a jury. How'd they do that? The state of Utah is seeking a death penalty against Robinson. Okay, so what? It's either fair or it isn't. It doesn't make it have to be more fair. It has to be fair. Nobody's undermining that. By the way, nobody wants Tyler Robinson to be unfairly convicted. Like if the guy didn't do it, we're not like, well, we have to convict him. I think he did. All the evidence says he did, but we want to have transparency in the process. All participants in this proceeding have a duty to ensure that Robinson receives a fair trial and a reliable penalty proceeding. This may at times necessitate closure or filings being marked private. And so we're going to conform with the rules, but anything more than the rules, including closure notices that we don't even have to tell the media about, we want you to enforce. Signed by the defense team in the Tyler James Robinson case. Now, the judge came out with an order, and we're marching towards a closure hearing, so hopefully this judge keeps this thing open, man. I'm going to be very upset if he doesn't. But he says the following. Charlie Kirk case, Tyler James Robinson says, all right, the rules in Utah, they provide that court records are public unless otherwise classified by this rule. There is a presumptive right to access public court records. They're saying just the files. However, the public's right to access is not absolute. The rules allow a party to file a motion to classify a record as non-public. When a motion to classify a record has been filed, the party filing the motion must serve the motion on any representative of the press who has requested notice. Now, the court got requests from a lot of people. Salt Lake Tribune, Jessica Miller, St. George News, AP, Fox 13, CBS, CNN. They all came in as the media interveners. They all said, you guys can't lock this down. Like, this is ridiculous. Because even the prosecutors were agreeing and doing stuff in private. It says you have to notify us if you're going to classify and make things private. The court has also received requests from Deseret News, Deseret Digital Media, and many others for notice. Now, the parties filed a joint motion to order a transcript of the hearing and classify both the transcript and the audio as private. The parties filed a joint motion, so the defense and the prosecution, to order a transcript of the hearing, so they have it for their cases, and to classify the transcript and the audio as private. Joint motion. Prosecutors are agreeing with the defense to keep this thing sealed. Private, you can't see any of it. How come? Why would the prosecutors want to do that? This is a motion to classify. Do they have classified material? I thought it was Tyler Robinson, pretty clear, pretty clear as day. What is there classified information that's going to be harmful that the jury is going to be prejudiced by if it comes out? This is a motion to classify. We'd like to see what the motions are. Don't need the classified info, but what's the motion? To close a court record that is subject to the process right here. Okay. So saying if you want to close this, then we'd have to provide notice. So the parties are now ordered. This judge is doing a good thing. The prosecution and the defense want to lock it down. The judge is saying you have to notify the media. They've requested notice, notify the media and send them your motion. Then they can be a part of it. The court orders that all future motions to classify a record must be served on representatives of the press. Great job. The parties filing the motion is responsible for service of the motion. The court is required to hold a closure hearing in the following circumstances. When a motion or petition to close a record is contested, the media will contest. When the press has requested notice of closure, or when the court decides public interest in the record warrants a hearing. Because the press has requested notice, the court will now set a closure hearing at the earliest date available for all parties, including representatives of the press, to be present. The press has a right to be heard at this hearing. Representatives of the press may file their respective positions in writing before the hearing if desired. In deciding whether to classify, the judge can look at anything, any relevant factor or policy signed on the 10th day of November by Judge Tony F. Graff. And this is not a ruling as a motion on the media interveners. That motion needs further briefing. The court will not rule on that until we get a request for a decision. Email to everybody. Yeah. The prosecutors are also trying to bury a lot of this stuff under seal, playing a little secret patty cake game. If the press had not moved to intervene, we may not have known about any of this stuff, and we're happy the judge is acting accordingly. So we're going to keep our eye on this, but a closure hearing, the judge said, will be coming soon. As soon as we get dates from the media, we'll decide how much of this can be locked down or not.